In this lesson, we're going to go over our case brief for Alaska Packers Association v. Domenico. This is a U.S. Court of Appeals Ninth Circuit decision from 1902. If you want to follow along with me as I work through this case brief, simply visit studicata.com/case-briefs. And from there, you can just search Alaska Packers. Case should pop up. You just click on that. You'll be good to go if you'd like to follow along with me as I work through this case brief. So just for some quick background though, before we get into the facts here, this case centers on consideration as a requirement to contract formation. So for this case, we want to understand consideration at a really broad level before we just jump into it. This is going to help us understand the court's decision in Alaska Packers Association v. Domenico. So if we're thinking about consideration as a requirement to form a traditional enforceable contract, we understand at a big picture level, to form a contract, a traditional enforceable contract, there's two big requirements. We need mutual assent between the parties, and we need that mutual assent to be supported by valid consideration. Of course, mutual assent is just a meeting of the minds. We're looking for a valid offer, valid acceptance of that offer. That typically gives us mutual assent between the parties. Our next question in determining whether we have formation of a traditional enforceable contract is whether that mutual assent is supported by valid consideration. Typically, we think of consideration as legal value in a bargained for exchange. And we're thinking about legal value. We really want to see that the promisee is incurring a legal detriment. This is like always the first step in our consideration analysis. We're trying to determine whether mutual assent is supported by consideration. The first thing we should look at is, well, is our promisee here incurring a legal detriment? Which basically just means, is our promisee promising to do something they're not already legally obligated to do? Or is our promisee promising to refrain from engaging in an activity that they're legally allowed to engage in? So for example, right, just to make this easy, let's say that I promise my niece $1,000. I offer her $1,000 if she obeys all traffic laws for 1 year. I say, niece, if you follow all the traffic laws in our jurisdiction for the next year, I will give you $1,000. And she says, that's a great offer, Uncle Michael, I accept. So maybe we have an offer and acceptance, right? The question is, in terms of whether we have a contract, a traditional enforceable contract, will be whether that offer and acceptance, that meeting of the minds, that mutual assent we have, is supported by valid consideration. So first question, is the promisee here incurring a legal detriment? Is my niece here promising to do something she's not already legally obligated to do? Or is she promising to refrain from something she has a legal right to engage in? And the answer there is actually going to be no. My niece is not actually incurring any legal detriment here. All of us have a duty imposed on us by law to obey traffic laws. So when my niece promises to obey traffic laws, she's not actually incurring a legal detriment for consideration purposes, right? So really, that's just a gift promise from me. I'm just offering her a gift of $1,000 because she's not incurring a true legal detriment. Agreeing to obey traffic laws is something she already has a legal obligation to do. She has, every time she gets in the car, law imposes that duty on her to obey all traffic laws. So since she's not truly incurring a legal detriment, there is no consideration. We don't have legal value in a bargain for exchange. The court would view that promise by me to my niece as basically just a gift, a promise to give her $1,000 in exchange for nothing because she's not incurring a detriment. Okay, which is not going to be valid consideration. So we would not have formation of a traditional enforceable contract based on those facts. If you can see that example, if you can see how that agreement between my niece and I is not supported by consideration, you should be able to see this in Alaska Packers. It's actually kind of a similar idea, a similar concept is really an issue here in Alaska Packers. Okay, with that, we can just jump right into the facts here in Alaska Packers. Keeping this example we just went over in mind, let's get into the facts here. So The case arose from a dispute between the Alaska Packers Association, Alaska Packers, and a group of its employees over a contract renegotiation. Initially, the employees had entered into a contract with Alaska Packers on March 26, 1900, in San Francisco, agreeing to work as sailors and fishermen for the 1900 fishing season at Pyramid Harbor, Alaska. The original contract stipulated that each employee would be paid $50 for the season plus 2 cents for each red salmon caught. On April 15, 1900, an amended contract was signed increasing the season's pay from $50 to $60 while maintaining the per salmon payment. Upon arriving at Pyramid Harbor, Alaska, and starting their work, the employees ceased operations on May 19, demanding $100 for their services, significantly above the agreed amounts. Under the pressure of a short fishing season and the impossibility of replacing the workforce, the company's superintendent, without authority, agreed to the demand by drafting a new agreement stipulating the $100 payment. However, of course, upon the season's close, Alaska Packers refused to honor the new agreement. The employees then sued Alaska Packers to recover the full amount promised under the new agreement, alleging they had demanded increased wages because the fishing nets provided by Alaska Packers were defective. Alaska Packers argued the fishing nets, of course, were not defective and asserted the new agreement was invalid because it had been made without consideration and under duress. Ultimately, the trial court found that Alaska Packers had not provided defective nets to the employees, so the nets were actually good. Despite this, the trial court ruled in favor of the employees, and Alaska Packers appealed, which takes us to the U.S. Court of Appeals for the Ninth Circuit. And so for the Ninth Circuit, the primary legal issue was whether the new agreement, which had been made under the threat of work stoppage by the employees and promised them $100 each for their services, replacing the original agreements, was supported by sufficient consideration, given that the employees were already contractually obliged to perform these services. The Ninth Circuit Court held that the new agreement was not supported by sufficient consideration and therefore was not binding. Alaska Packers had the judgment entered in its favor, effectively nullifying the new agreement that promised the employees $100 each for their services. Okay, so the easy way to look at this from a big picture, basically what has happened here with Alaska Packers is we have our employees, our fishermen, our sailors, they enter into an original contract, right? So when that original contract is formed, we know once a contract is formed, that imposes legal duties on both parties to that contract. So imagine when that contract is formed, Alaska Packers has duties imposed on them, and the sailors, the fishermen, the employees, they all have duties imposed on them. So those duties are now set, okay, by law. This is what contract law imposes. This is kind of like in our example with my niece. Remember how we said traffic law is imposed on everyone? So when my niece promises to obey traffic law, well, we say, well, she has a pre-existing legal duty to do that. She's not incurring a detriment, so there's no consideration. It's the exact same thing here. Well, this original contract has imposed these duties on the employees. Basically, this is how much you're going to get paid for these services. So when they just randomly demand more money without changing what their services are, right? Well, they're not adding any new consideration. They have a pre-existing legal duty to perform the services at the $60 rate, right? So just demanding $100, $40 more than what they had agreed to without changing the agreement in any other way. Right now, if they had agreed to do more stuff, that could be different. If it was like, here's what your services are going to be for $60, but hey, if we do these additional things and this and that, and we change the agreement, maybe that could be new consideration. But when you keep basically the legal duty that was already imposed by the original contract the exact same, and you just want more money, and you're not actually agreeing to do anything different for the additional money, well, you already had a pre-existing legal duty to perform the services at $60. So you can't artificially just demand $100 and without additional consideration, right? That's not going to form a new contract, okay? So the court basically says a promise to do what one is already legally bound to do cannot serve as valid consideration for a new contract. Because it was promised solely on the employees agreeing to perform the same services they were already legally obligated to perform under the original contract, that new agreement lacked consideration. Again, because it was promised solely on the employees agreeing to perform the same services they were already legally obligated to perform under the original contract. So basically, the takeaway rule here is very simple, right? If we're dealing with a contract that is governed by common law principles, like is the case here in Alaska Packers, if you are going to have a new contract, you need new consideration. This is like me promising to pay my niece $1,000 if she obeys traffic law. She already has a legal duty to obey traffic law. That is not consideration. It's basically just giving her a gift, right? Which is not consideration. That's not a traditional enforceable contract. We need the promisee to incur a legal detriment. They have to promise to do something they're not already legally bound to do, or refrain from doing something they have a legal right to engage in. That is what is required to have consideration. So when a contract imposes a duty on you, that's a pre-existing duty, the same as a traffic law being imposed on you by the legislator, right, or the government. Okay, so that's the best way I think to view Alaska Packers. One note I would say before we close this out that I would just be cognizant of, this kind of rule only applies to contracts that are governed by common law principles. If we have a contract that is governed by Article 2 of the Uniform Commercial Code, right, which of course would be contracts typically that deal with the purchase and sale of goods, we understand that contract modifications might be subject to different rules. It is possible under Article 2 of the Uniform Commercial Code to modify a pre-existing contract without new or additional consideration, so long as that new agreement, that modification is made in good faith, right? And, there's actually some other rules that you want to be aware of. We have an entire video lesson that breaks down how contract modifications work with consideration under common law principles and under Article 2 of the Uniform Commercial Code. But you'd want to be aware of both approaches. I would watch that video if you have questions on that. Just something to be aware of here as we're thinking about this. And one other note along that same line I would make in terms of the court's reasoning here is one of the big reasons, we see the court reasoning that if we're going to have a new agreement, there should be new consideration, is to prevent this type of bad faith kind of thing here, where the employees, where it's seen by the court at least, that the employees are just demanding more money because they know they can, right? It's a short fishing season. They know there's going to be pressure on Alaska Packers. They know they can't get a new workforce to Alaska in time for the fishing season. So they're like, hey, we can demand more money, and they're going to have to pay it because they have no alternative. Right, that type of bad faith negotiating is kind of why the court, at least in this opinion, is reasoning, hey, if we're going to have a new contract, that new contract should be supported by new consideration. And so the way Article 2 of the Uniform Commercial Code deals with this is they actually put in the code, hey, the modification has to be made in good faith. Okay, even if it's not supported by new consideration, it still has to be in good faith. So Article 2 of the Uniform Commercial Code still deals with kind of the court's reasoning here from Alaska Packers, but in a little bit of a nuanced way. Again, we have a whole video that breaks it down. Don't want to get into all of it right here. If you're interested, go watch our video on contract modifications and consideration. Breaks it all down. But with that, that is Alaska Packers Association v. Domenico, U.S. Court of Appeals decision, Ninth Circuit opinion from 1902.